Honorable Judges, Judge Mark Macareg, Judge Eden Macabulos, Judge Teresa Gonta, and Judge Luis Pascual presiding.
All right, thanks. Okay, can we have entries of appearance?
Your Excellencies, good afternoon. May it please the Court. My name is Joyce Marie Sufrea, appearing as first agent for the United Empire of Atenean. Together with my co-agent, Mr. Rafael Romulo, we respectfully enter our appearance on behalf of the United Empire of Atenean. For the first counsel, we indulge 14 minutes for my submissions, and 14 minutes for my co-agent submissions, and 2 minutes for rebuttals should the need arise. Thank you, Your Honors, and may it please the Court.
Respondents.
Mr. President, Your Excellencies, good day. My name is Lara Sofia R. Angada, First Agent for Respondent Gustavo. Together with me is my co-agent, Ms. Bianca Isabel A. Balir. It is an honor to appear before this court today. With your indulgence, I respectfully request 14 minutes for my submission, 14 minutes for my co-agent submission, and 2 minutes for sir rebuttal should the need arise. Thank you, and may it please the Court.
Thank you, agents, for your entries. Can we have first applicant, please?
Mr. President, Your Excellencies, once again, good afternoon, and may it please the Court. My name is Joyce Marie Sufrea, appearing as first agent for the United Empire of Atenean. It is our submission that Rustavia is violating Article 1, Common Provision of the Geneva Convention. To prove this, Your Excellencies, I have 2 points. First, Rustavia violated Article 1 of the Common Provision of the Geneva Convention in violation of 3 principles. One is the principle of distinction, second is the principle of proportionality, and last is the principle of precaution. To our second submission, Your Excellencies, Rustavia violated Article 1, Common Provision of the Geneva Convention by its violation of Article 35, Paragraph 3 of the Additional Protocols of the Additional Protocol 1 of the First Geneva Conventions. Allow me, Your Honors, to paint a picture of what happened with Atenean by Rustavia's deployment of ASIL.
Agent, before you go on, I'm pretty old school, at least from where I came from. The Geneva Conventions apply when there's an armed conflict and when international humanitarian law applies. How would you argue the application of the Geneva Convention in this particular situation when traditionally I don't see any exchange of gunfire or movement of troops?
Mr. President, the applicant submits that in the situation of the deployment of ASIL, such constituted armed conflict, Your Excellencies, that triggers the application of the Geneva Convention, and such Rustavia violated Article 1, Common Provision of the Geneva Convention.
How? So if for example, if you remember the I love you virus or whatever, cross borders, hacks computers, is there an armed conflict? Is that an armed attack?
Your Excellency, the applicant submits that ASIL, the Autonomous Self-Replicating Information Loader, is a malware virus. However, it's not in the conventional sense of armed attack, as seen in the past cases on this court rule. However, it is our submission that in light of Lex Data, Your Excellency, this court must interpret that the deployment of ASIL as a malware is now considered an armed attack, Your Excellency. And as such, Your Excellency, They violated Article.
Agent, how was ASIL an armed attack? How can you say that it's an armed attack? What is an armed attack anyway?
Your Excellency, applicant submits that in prosecutor versus established, armed attack was found when such that there is armed forces involved. Here, Your Excellencies, ASIL was deployed under the direction of Premier Pangilinan of Rustavia, and it was with the Rustavia Secret Service.
Hold on. So if it's directed by an armed force, it's automatically an armed attack.
Your Excellency, it is our submission that there is gravity to it that the military forces of that state instigated that attack and deployed such. And we also look at the effects of that deployment. That's why in this case, Your Excellencies, it is our submission that when they deployed ASIL to Abelugia, it caused an armed attack. And as we see from the compromise, if I may point the court to paragraph 27, in there, Your Excellencies, when Rustavia successfully deployed the ASIL to Abelugia, what happened was the people were not informed that there would be a release of water. As such, the people did not anticipate such water. And how many people died, Your Excellencies? There were 5,000 deaths recorded in the state of
Agent,
Abelugia.
just a clarification. You mentioned earlier that it is not the conventional way of viewing armed attacks. And you're asking us to, based on the facts now, consider this one as an armed attack. Is there a change in standard of when an armed attack exists? If there's a change, when did that change happen and what's your view?
Your Excellency, it is our submission that this court must interpret it in a progressive manner. It is our submission that this court look upon the talent manual as basis, Your Excellency.
What's in the talent manual?
The talent manual, Your Excellency, is written by most highly qualified publicists.
And they have changed the standard? Is that what you're saying?
Yes, Your Excellency, they have. In fact, the talent manual,
Oh, they have
Lincoln,
changed. So we only need an MHQP for us to change the standard of things in international law. We don't need state practice, none of those things. Just an MHQP telling us, hey, this is the new version of an armed attack.
Your Excellency, it is our submission that in light of the talent manual, which has persuasive and authoritative effect to this court, must be looked into as an interpretation now of what constitutes armed conflict. And it is our submission that when there is a cyber operation...
Agent, sorry, your answer to your question is yes. If there is an MHQP who says that there's a change in standards, then this court must follow that MHQP.
Your Excellency, to clarify this, it is our submission that the court may look into it, that the court may, based upon its decision...
Does the MHQP change the standard or not?
It does, Your Excellency.
So,
Yes, Your
so
Excellency.
we must follow the MHQP who changed the standard.
It is our submission that, yes, Your Excellency, in light of the progressive changes in international law, and we are not confined anymore with traditional and conventional warfare, Your
Yes,
Excellency.
MHQPs, are those primary or subsidiary sources of international law?
Your Excellency, MHQPs are subsidiary sources, and although they are subsidiary sources, Your Excellency, they still have much and authoritative weight before this court, Your
That's not
Excellency.
my concern. I think our concern is more of, does it actually have the power to change rules?
Your Excellency, it does have power to change rules.
Subsidiary sources alone?
Your Excellency, alone subsidiary sources cannot. However, in this matter, Your Excellencies, the subsidiary sources that I am referring to, which is the talent manual, interprets how armed attacks are. And it is our submission that now, in
So it
fact,
interprets what?
it interprets when there is an armed conflict,
On
Your
the
Excellency.
basis of what? What primary source are they interpreting?
They interpret this, Your Excellency, on interpreting the use of force under the UN Charter. However, it is our submission that when there is use of force, although...
Sorry, Agent. What's the relationship between an armed attack and use of force under the UN Charter?
Your Excellency, the relationship is how this court and other
Are they the
authorities...
same? Armed attack, use of force?
Your Excellency, it is our submission that they are not the same.
So if they're not the same, what's the basis or what's the weight of an interpretation of an NHQP of use of force under the charter to an existence of an armed attack under a totally different body of law?
Your Excellency, although we acknowledge that they are different, the two sources can be harmonized in interpreting what are armed conflicts. Since this court, in its past cases, when there is an involvement of armed conflict, pardon, Your
Which
Excellency.
cases, Agent?
Your Excellency, for example, in the Nicaragua versus the United States case, there was a mention of armed conflict, but this court did not elaborately define what an armed conflict is. And as applicant, it is our submission, within the line of cases mentioning armed conflict, that now cyber operations must be interpreted as an armed attack. And in light of that, the Geneva Convention will now apply in this matter.
What are these line of cases that you are referring to, and what was the ruling of this court in those cases, Agent?
For example, in Nicaragua versus the United States, Your Excellency, this court ruled that there was an armed attack in light of the sending of the United Nations, the United States into Nicaragua of those military armed forces in light of the
An
national.
armed attack, Agent, not an armed conflict.
Your Excellency, it is our submission that this court has used armed conflict and armed attack interchangeably, and such that when these two concepts are intertwined, these two concepts must be harmonized in reflecting the situations of the other, and such that here, when we interpret armed conflict, there is that involvement of force in employment of that armed conflict.
For example, Agent, take for the meantime that we don't accept your argument that an armed conflict exists. Is Common Article 1 of the Geneva Convention still applicable?
Your Excellency, yes, the Article Common 1 of the Geneva Convention is still applicable, even though there is no armed conflict. In fact, Your Excellency, Article 48 of the Geneva Convention is still applicable, which talks about distinction in employing means and methods of war, Your Excellency. So even though the respondent will submit that the deployment of ASIL is not an armed attack, they still have the duty to ensure that employing ASIL would not violate the principle of distinction, Your Excellency. To continue, Your Excellency, to the discussion of distinction and how Gustavia violated such. Under Article 48 of the Additional Protocol 1 of the Geneva Convention, it enlightens us that when states employ means and methods of war, they must have a distinction.
Agent, what's your definition of means and methods of war?
This is our submission that when we talk about means and methods of war, these are measures that are taken by the state to address a certain military objective, Your Excellency.
So regardless if it's physical or not, regardless of the effect, regardless of the impact, if it's to address a military objective, it's a means or method?
Yes, Your Excellency, it can vary as well. Not limited to any circumstances, but it is the state's election of which methods of war are they going to use, Your Excellency.
And your basis for this definition?
A basis for this definition is the commentary on the International Committee of Red Cross, interpreting Article 1, Common Provision of the Geneva Convention.
Has there been an application of something cyber, something virtual, and it is thought to be falling under means or methods of war?
Your Excellency, this court or other tribunals has not yet ruled upon the matter. As such, it is our submission that this court take upon this interpretation that now cyber attack should now be interpreted as an armed attack to further elaborate.
Maybe not this court, state practice or condemnation of states. Did they ever consider something like that as a means and method of war?
Your Excellency, other states has not yet done so in line of state practice. But this court,
There's nothing that we're working on here. So the Italian manual isn't interpreting anything because you're saying now that there's no case, state practice, custom, event, whatsoever.
Your Excellency, it is our submission that it is not a wide state practice. However, some states, such as the United States, already has rules when it comes to cyber attacks. but not in a regional or continental
So what's the
application.
basis of some states when it's not widespread?
Your Excellency, one instance would be in the United States in the deployment of cyber attacks against one of the
No, I don't think you're getting my point. What's the point of considering the practice of a few states when that practice is not widespread?
Your Excellencies, in considering this, it does not matter under international law how many countries practice such. It is important and imperative with this court that when there are a sum of number, it may already consider such.
You're talking about state practice in Boston?
I'm talking about, Your Excellency, in considering how the interpretation of armed conflict should be, Your Excellency.
Sorry, in interpreting something, the court can resort to the practice of a few states. That's your point?
Yes, Your Excellency, there is no standard of how many states should practice a certain custom for it to be ruled as state practice.
So state practice is now subsidiary in nature. You use it to interpret something. Am I getting it right?
Your Excellency, it is our submission that Your Excellency, can I ask for a few additional minutes just to wrap up and to answer your question?
Just answer my co-judge's question, then I'll give you 30 seconds for that.
Your Excellency, state practice is not subsidiary. However, the court may look into it as a primary source in interpreting in favor of Abelugia that now cyber attacks should be considered as an armed conflict. In some, Your Excellencies, Abelugia asked this court to rule that Rustavia violated Article 1 Common Provision of the Geneva Convention in its violation in observing proportionality, distinction, and precaution. And second, Your Excellency, it is our submission that Rustavia be liable due to its violation of its deployment of ASIL to the environmental harm that caused Abelugia. Thank you, Your Honors, and may it please the court. Once again, my name is Joyce Freya, appearing as first agent for Abelugia.
Second agent for that.
Your Excellencies, good day. May it please the court. My name is Rafael Robert, the agent of the applicant. Allow this counsel to forward 2 points. Firstly, Abelugia is not liable for the environmental damage. And secondly, it must not pay compensation. Members of the court, we are faced with an unfortunate...
Agent, sorry, before you go to your points, it appears that your first agent was not able to finish your submissions. Are you able to continue?
Yes, Your Excellency.
We'll give you maybe in 1 minute. Can you give the rest of your submission?
Yes, Mr. President. In regard to the precautionary principle, most highly qualified publicists mentioned that the same as an activity that is to be avoided when there's a lack of scientific data. In this particular case, the ASIL, as stated in the compromise, was too good at its job. Because of the same, it was incumbent upon Rustavia to refrain from using the deployment of ASIL. Now moving on, members of the court, we are here facing
So
the
what could they
unfortunate.
have done? If not that, because you're saying they could have recovered me, whatever, taking precautions, whatever. You weren't responding to them. Were they supposed to wait until you poison everybody in the region?
Your Excellency, it was merely 5 days.
5 days is too long for something as stricken as this.
We respectfully do not share the same opinion, Your Excellency, as we believe that we were addressing the Abeluvian nuclear power plant explosion. In fact, under the compromise, it stated that CBR and military officials of Abeluvia were there immediately, and in 3 hours we were able to take out the fire and the explosions. In fact, Your Excellencies, we were doing everything that we could to stop the explosion. Your Excellencies, in the pulp mills case, the court explained the due diligence obligation in preventing transboundary harm. The same diligence requires a certain level of vigilance in the adoption and enforcement of measures and regulations in preventing the same. It is the applicant's submission that we have fulfilled this obligation. Firstly, the hiring of Dr. Marielle. She is a renowned nuclear engineer. In fact, if I may assist the members of the panel to paragraph 6 of the compromise, it stated that she already spearheaded 15 nuclear power plants. She has been in this industry for 50 years. Although
Right,
some of her
but
investigations...
exactly, I was going to
Yes.
ask you about that. She has a shady past as well. Isn't the duty to exercise diligence contingent with selecting the proper persons to head such a sensitive and potentially dangerous project as that, as the nuclear power plant?
Certainly, Mr. President. However, as stated in paragraph 6 of the compromise, it stated that the IAEA investigation absolved her of any blame. In fact, it was a recognition that her safety measures of the ANPP were enough. Secondly,
Yeah, but you went beyond those like safety measures, right? There were safety measures in place, but you exceeded those intentionally.
it is the respondent's submission that the Abeluvian state was taking into consideration a renowned nuclear engineer. It provided that Dr. Marielle advised to her best of capabilities. However, in the operation of anything, if nuclear power plant or anything at all, there is some risk. And this risk was not foreseen by the Abeluvian state. It did everything it can, as required in the pulp mills case, a certain level of vigilance. And thirdly, members of the
But
panel.
wasn't your state aware that once you raise it to 25%, it can potentially lead to an explosion or any catastrophic damage? That's why initially you only did 20%, right? If you were not mindful of the risk, then applicant could have increased it to 25% in order to fulfill the energy needs. So isn't that a tacit admission that there was some level of danger and risk involved in increasing the capacity?
Your Excellency, I would like to address your question with 2 points. Firstly, if I may assist the members of the council to paragraph 6 and paragraph 12 of the compromise. Dr. Marielle downplayed the risk as minimal and stated that automated systems were enough to prevent any untoward nuclear accident. And secondly, Mr. President, the operation...
Sorry,
of the
before you
ANPP
go to your second point, you earlier represented that the risk was unforeseen. How could it not have been foreseen when the risk was already addressed by the doctor?
It was, Your Excellency, the applicant submits that it is unforeseen because we were following the directions of a renowned nuclear engineer, and she has
How do you
50 years of
define
experience.
unforeseen? How do you define unforeseen?
Unforeseen is any incident that is incapable of having foresight. Therefore,
You knew there was a risk, right?
Your Excellency, in the conduct of anything, there is
Yes or
a
no?
risk.
Yes or no?
Yes, there is a risk.
So, was it foreseen or not?
The explosion of the ANPP was unforeseen because the risk, as already stated in paragraph 12 of the compromise, was only minimal. The risk that the respondents are
It's
trying to
whether
blame
one thing can happen or not is totally different from the likelihood of it happening or not, correct?
However, the
Yes or
applicant-
no?
Yes.
So what does foreseeableness apply to? The first one or the second one?
It is unforeseeable to the explosion of the ANPP.
Wait, it's the likelihood of one thing happening or knowing whether one thing can happen or not?
Likelihood and probability, or possibility and probability.
The probability.
So it's unforeseen probability-wise, but not possibility-wise. So something can be foreseen as to this is a potential risk, but it's unforeseeable because there's just a 1% chance of happening. Is that your position, Ethan?
Yes, it is our position. And
Any
se-
basis for that, by the way?
Yeah.
any interpretation, any commentary that would take that position of probability over possible, unforeseeable?
The applicant submits that in the Corfu channel, the ICJ stated that a state must not knowingly or knowingly allow its territory to be used in contravention of the rights of other states. In this particular case, members of the court.
Agent, sorry, you did not address the question. What's the basis for your this definition of foreseeable?
That one we just discussed.
The probability.
It's interesting. It's actually quite new, I think, to many of the ears of this court. Well, hopefully, if you can justify that would be good. Because I think it's quite unusual. Go ahead.
Your Excellencies, this is why we are here before the court. Although
Wait, do we have a
was-
basis or not?
I know the applicant does not have a basis in regard to that particular matter. However, Your Excellencies, this is why we're here. We want, the Abeluvian state wants justice, and it believes that it is not at fault for the radioactive material which caused Rustavia's biggest fish kill and human lives affected. In fact, members of the court, if I may assist the counsel to paragraph 16 of the compromise, which stated that the IEA stated that Tabitania contributed to the radioactive material in the Jessar River. In fact, prior to Tabitania's engagement, the average radioactive engagement of humans is only 300. However, in this particular case, the radioactive material found in the Jessar River is 25,000. It is not the Abeluvian state who must be at fault here. Furthermore, members of the court, under customary international law, it is incumbent upon states to notify about the existence and to warn neighboring states about an imminent and existing danger within its territory. In this particular case, the Abeluvian state has complied with the same. If I may assist the members of the council.
In any issue in international law about state liability, one primary issue is always attribution. Are you conceding attribution?
No, we are not, Mr. President. However, it is the applicant's submission that it is Tabitania who has committed an internationally wrongful act.
So for you, completely no responsibility. It's just Tabitania not to be at fault.
Yes, Your Excellency.
Even if the radiation increased after the lockdown.
Yes, Your Excellency. It is Tabitania's fault.
But you're the applicant, right? Why didn't you include Tabitania then?
It is the applicant's submission that we are trying to deny any fault in this particular case. However, there
For
is
the counterclaim. Or why didn't you cross-claim? Is there a cross-claim, by the way, under the ICJ rules?
Mr. President, our action before this panel
Agent,
does not
yes or no?
preclude.
It's a simple question.
Can the state do a cross-claim under the ICJ rules?
No, Mr. President. What the applicant is, it may not,
What's your basis?
Your Excellency, according to the ICJ statute. However,
Which provision in the ICC statute says that?
the applicant may not forward the exact provision. However, it is the applicant's submission that cross claims may not
How
happen.
about counterclaim?
Yes, Your Excellency.
Basis.
The ICJ statute.
Statute? Statute?
The ICJ rules of court.
Which is
Your
which?
Excellency.
Statute
The,
rules of court.
the rules of court.
Final answer.
Rules of court. Your Excellencies, it is Tabitania who's at fault. As stated in the compromise, the miners were ejecting radioactive material in the river. Under Article 2 of the RCWA, there is an internationally wrongful act when, firstly, an act or omission is attributable to the state, and secondly, when the conduct breaches an international obligation.
Okay, let's go back to attribution. You said that it was not attributable. You're not conceding attributability. But the actions were clearly done by who? Emperor Gines? What's the name of the person? Emperor Gines, Dr. Variel, all of these people, aren't they your agents?
It is the applicant's submission that despite the overriding of the ANPP, it did not breach any international obligation.
No. Attribution first. Attribution. Before we go on to breach. So you're conceding attribution.
No, we are not conceding, Mr. President.
But I mentioned the names of these individuals who appear to be state agents of applicant. So how do you disclaim that their actions are not your state's actions?
Mr. President, I would like to clarify that Emperor Ginezo, in his official capacity, authorized the overriding of ANPP safety measures. However, in order for internationally lawful act to be responsible to a state, it must also satisfy the second requirement under Article 2, which is to breach an international obligation.
Okay, so you're conceding the first element, but not the second.
Yes, Mr. President.
Okay.
So moving
So
on.
you are conceding attribution, basically, but not liability.
Yes, Your Excellency.
Go ahead.
However, it is also the respondent's submission that Tabitania is at fault here. In the US versus Duran case, the ICJ stated that the private acts of a state is consummate to the acts of the state. Therefore, the acts of the private minors in this particular case is attributable to the state. And secondly, Tabitania committed an environmental harm in the prevention of transboundary environmental harm by allowing its miners to eject radioactive material into the Jessar River. Therefore,
Counsel, by attributing fault on Tabitania, does that do anything that will change the claim on liability of the applicant? How does that affect it?
Your Excellency, 3 points. First of all, the Abeluvian state did not commit any internationally lawful acts. Therefore, it is not the state's responsibility for any environmental harm. And secondly, we are moving forward that Tabitania is at fault here. And thirdly, it must not pay compensation. As in the case of Costa Rica versus Nicaragua state, said that a state is liable for an internationally lawful act and contributes to environmental
You're
damage.
not answering the question. So again, you keep repeating this. The other state's fault and no fault, zero from you, correct? Okay, but the IAEA report said that, okay, the disaster could not have been as bad as they are if it were not for Tabitania's terrible practice. Not as bad, but it is bad. I mean, it's just worse because there's, Tabitania did something else prior to your explosion. But it is still bad, right? So you can't deny complete liabilities because it is still bad. You still caused something. It just became worse, or it's just at this gravity because of Tabitania, but you have something to contribute to this damage, right?
Your Excellency, considering that my time is over, may I ask for an extension of 1 minute to address the question?
Just answer the question and then end it. 30 seconds.
The Abeluvian state has no responsibility in the environmental harm. As stated in paragraph 16 of the Compa Rule, it stated that an average human experiences 300 millirems in a year. In this particular case, the Abeluvian state, if ever, radioactive material into the Jessar River was merely 500. And according to studies provided by the CDC, a 500 millirems does not constitute any radioactive chronic syndrome. From all the foregoing, it is our submission that the Abeluvian state is not liable for any environmental harm and therefore must not pay compensation. If there are no more questions, then I will cede the floor to the opposing counsel. Thank you, and may it please the court.
Thank you, agent. Thank you, applicant. Okay, first respondent.
Again, my name is Lara Sofia R. Andrada, First Agent for Respondent Cristavia. As First Agent, I am tasked to discuss Respondent's first prayer for this court to declare that Cristavia did not violate Common Article 1 of the Geneva Conventions. Because first, international humanitarian law, or IHL, does not apply to cyber operations. Second, there is no armed conflict between Abilivia and Cristavia. And third, Cristavia did not violate the provisions of the Geneva Conventions and its additional protocols. Going to the first point, IHL does not apply to situations of cyber
Hey, Judge,
operations.
before you continue, I heard something from the first applicant earlier, essentially saying that even if there's no armed conflict, there could still be a violation of Common Article 1. Do you agree with that?
Yes, Your Excellency, we agree that even without the armed conflict, there will be, or Common Article 1 of the Geneva Conventions may be applicable. This is because Common Article 1 provides that the high contracting parties must respect and ensure respect for the Geneva Conventions at all circumstances.
So, go ahead.
Then given that concession, how does that change your outline? Is it still relevant that we hear the arguments on the existence of an armed conflict and the application of IHL?
Yes, Your Excellency.
Why? Because it will apply regardless, right?
Your Excellency, this agent submits that IHL does not apply to cyber operations. And if cyber operations will not be applicable in this case, there will be no need to talk about the violations of Cristavia. And even assuming...
But the claim of the applicant is grounded on Common Article 1 of the Geneva Conventions, which you concede as agent will apply regardless of whether it's IHL or IHRL, or no armed conflict or no armed conflict. Now, your justification is you still need to discuss the existence of an armed conflict because it will determine whether cyber attacks fall within that scope. Because why? Because it will determine whether they're liable or not. But the claim is under Common Article 1, which is, you see the tautology there, the contradiction. So how do you resolve that contradiction?
Your Excellency, this agent will go to its submission regarding the Common Article 1. Common Article 1 applies, as mentioned, regardless of whether IHL applies or whether there is an armed conflict or not.
Better, okay, proceed.
This requires that the states party to the Geneva Conventions must comply with the provisions of the Geneva Conventions and its additional protocols. And in this case, Cristavia complied with the provisions of the Geneva Conventions and its additional protocols. The first principle of international humanitarian law is distinction. Based on additional protocol 1, states are required to distinguish between protected persons and objects, such as civilian persons and objects, against combatants and military objectives. And in this case, Cristavia complied with that. Under paragraph 25 of the compromise, the ASIL, or the Autonomous Self-Replicating Information Loader, was specifically created.
Agent, Common Article 1 is just a matter of respect. Correct?
Yes, Your Excellency. Respect and
ensure
assurance.
respect. You hacked into their system. Is that respectful? I mean,
Can you be a respectful hacker?
I mean, we get it. How is that ensuring respect? You hacked into some other state's computer, and it's a national property. We don't even need to talk about whether it's a cyber attack or whatever right now. I'm just looking at Common Article 1, and this is what it tells me. So how is that in line with respecting and ensuring respect?
Your Excellency, although it may seem unrespectful at that, with that wording, it is still, or Cristavia still actually respected the Geneva Conventions in deploying the ASIL. Your Excellency, what applies in this case is use and bellow. And under
Wait,
this,
how? How there respect?
There is respect in this case because Gustavia still complied with the principles of proportionality and precaution, as well as distinction.
Okay, regardless of those principles, are you supposed to hack into some other country's system?
Generally, Your Excellency, no.
No.
However, in this case, Your Excellency, what applies is use in bello, which does not prohibit attacks per se, but regulates it.
Okay, hold on. It's used in bello, so you are conceding that there is an armed conflict.
This is the assuming that there is an armed conflict.
No, because, okay, it appears to me, to us, or to me, that you're saying, okay, no, you said earlier, right? You're not supposed to hack into another state's computers or whatever, but if there is armed conflict, then it is okay if I follow certain principles. Is that what you're saying?
Yes, yes.
So therefore,
You have to concede
you have to
there.
concede that there is an armed conflict. Because if there's no armed conflict here, then we will stop the discussion here. No, you cannot hack into someone else's computer.
Correct.
Correct?
Correct, Your Excellency.
So basically, you're saying that first applicant's speech is all through, like everything she said is admitted.
No, Your Excellency.
No, because our two arguments are there's an armed conflict, and the common article 1 will apply if regardless, right?
Yes, Your
So
Excellency.
both of her points are admitted on your end.
Yes, Your Excellency, but nonetheless, Gustavia still complied with the principles under IHL, which means that the deployment of ASIL still does not constitute a violation of the international humanitarian law.
Agent, what if IHL does not apply? What if there's no armed conflict? What you did, was that still permissible?
Your Excellency, what the
Yes
what,
or no?
It depends, Your Excellency.
On what?
It depends on the regime of law that will be applied.
Exactly, not IHL.
Yeah. So
So
for
please
example,
stand.
please
Again, you go back to the question earlier. You said no, but, and then your but was an IHL
But
regime. Yes. Now we go to the IHRL regime of that but. Is there a but there, or is it just plain no?
there's no respectful hacking at all. Can
Oh,
there be
even in
respectful
peacetime.
hacking?
During peacetime.
During peacetime. That's it. I guess that's the nutshell question.
During peacetime, assuming that there is another regime of law applicable, and what applicant claims a while ago that this could be use of force, it could fall under the UN Charter when there is an exception such as self-defense or when there is authority from the Security Council.
So the Security Council may authorize you to disrespectfully hack, or you can use disrespectful hacking as a source of
Self-defense.
If
form of
it will-
self-defense.
Yes, Mr. President, if it will constitute as a use of force as claimed by applicant, this may fall there.
Can
But
can you give examples of state practice or court or judicial decisions? I don't understand how disrespectful hacking can be a form of self-defense or can be authorized by the Security Council. Like practically, how would that look like?
Your Excellency, Mr. President, at this moment there is no case.
Okay, so even if there's no case, show me how it will look like practically. Like, will the 5 members of the UN Security Council, the permanent 5, authorize, for example, responded, okay, you can create a malware, virus, whatever, and then you can hack into the data of a sovereign state and try to divert whatever. Is that how it's gonna happen?
Possibly, Your Excellency, but this need not be discussed because this court cannot go beyond its jurisdiction, which the party submitted is only limited to the Geneva Conventions or the IHL regime of law.
Okay. So we will go back to IHL definitely then.
Yes, Your
Which is
Excellency.
basically the concession of the entire month.
Yes, Mr. President.
Okay.
Going back to the principle of distinction, the means used, which is a computer virus, also strengthens our submission that Gustavia complied with the distinction because although there were incidental deaths, they were much less than what would have resulted if Gustavia, say, bombed the diversion lab. Given that, under next principle. Proportionality under Additional Protocol 1 means that attacks and its incidental effects must not be excessive to the military advantage anticipated by a state. Death of civilians does not necessarily violate the principle of proportionality if it was conducted accidentally or unintentionally, and that there was no alternative to it.
Can you give me comparative cases discussing proportionality of military response as regards an objective? And can you give me the figures, like the numbers of how many people died and what was proportional under the circumstances? Give me an example.
Mr. President, apologies, but this agent cannot assist you with that question at this moment. But in this case, under paragraph 28 of the compromise, it was stated by Premier Panganana, the head of state of Restabia, that everything that resulted after the deployment of ASIL was unintended and unforeseen. Additionally, paragraph 28, under the same statement of Premier Panganana, it is stated there that Restabia has exhausted all manner of diplomatic settlement within reason.
Isn't there a logical connection between deployment of the ASIL and the resulting events afterwards?
There is, the resulting consequences afterwards was due to the deployment of ASIL.
You admit that.
Yes, Your Excellency.
So how can you not be liable for those consequences when you deploy ASIL, which caused that?
Your Excellency, because even if there were incidental consequences, this does not necessarily mean that Restabia violated the principle of proportionality, because the incidental effects were not excessive to the military advantage anticipated by Restabia. Going to the third principle, Your Excellencies, precaution under Additional Protocol 1 means that states must take all...
What's the standard of excessive? Again, I think the reason why we were asking James earlier is because we need a sort of standard. Because people died, right? Your objective was to just divert the water,
Yes, Your Excellency.
right? To just stop applicant from getting the poisonous water to your territory, right? That's why you diverted it.
Yes.
But people died, right? People died. So, I mean, to us, it's excessive already. Because it's not your target, but that happened in addition to your target objective. So it is excessive unless you give us a standard. Saying, in this case, Your Excellency, it wasn't considered excessive, so therefore, we must rule the same. So any kind of basis that can guide the court.
No need to be a case.
Yeah.
Your Excellency, seeing that I'm almost out of time, may I answer this question and conclude this agent's submission?
Answer the question and you get 30 seconds to wrap up.
Your Excellency, based on the ICRC commentary, a death of civilians will not be considered a violation and hence not excessive if it resulted from an accident or an unintentional act, and there was no alternative to it. But in this case, Your Excellencies, the incidental effects were not intentionally conducted by Restabia. In fact, Your Excellencies, the very purpose of the
The applicants did not intend for their machine or plant to explode. So, because it was unintentional, then they would not have the same answer. Correct? And
No, Your
that's what you're saying.
No, Your Excellency. In fact, in this case, there was no violation of precaution because
Just answer.
Just answer.
there was no violation of IHL here because there was also an exercise of precaution. And although it was not intended, applicant did not intend to divert the radioactive water flow there. They did not comply with their due diligence obligation to even respond to Restabia when Restabia demanded immediate action from the leakage of the nuclear power plant. This can be seen under paragraph 23 of the complaint. With that, Your Excellencies, your study did not violate Common Article 1 and the dwelling the ASIL. Mr. President, Your Excellencies, thank you and may it please the court.
Thank you, Agent. Second respondent.
Mr. President and Your Excellencies, good day. May it please the court. My name is Bianca Isabel A. Baluyot, second agent for the side of the Democratic People's Republic of Rostavia, and it is an honor to appear before the court this afternoon. Thank you, and may it please the court. Your Excellencies, this agent respectfully submits that the United Empire of Abenubia is not liable to the environmental damage and must pay compensation for the following 3 reasons. First, the acts of Emperor Van Henezo, which caused the environmental damage.
Agent, sorry, is not liable.
Liable, Your Excellency. First, the acts of Emperor Van Henezo, which caused the environmental damage, are attributable to Abenubia. Second, Abenubia violated its environmental obligations. And third, since the elements of state responsibility are present in this case, then Abenubia must pay Rostavia compensation for the environmental damage suffered by Rostavia.
Okay, Agent, before you proceed, considering what you heard from the second applicant, how does that, if ever, change the structure of your presentation?
Mr. President, applicant was submitting earlier that it was Tabetania who was ultimately responsible for the environmental damage. However, the ICJ's jurisdiction only extends to states who give their consent to be bound by the ICJ. And in this case, Tabetania is not a party.
Agent, I don't think applicant was saying we can't be liable because they are liable. They're just saying it's not us, it was them. So ICJ jurisdiction or not, if it was someone else's fault, then we can't blame them.
Your Excellency, they were discussing that indeed under attribution. However, attribution under the Articles of State Responsibility by the ILC determines whether or not an act is attributed.
No, we're not talking about attribution to state agent, state itself. They were talking about it was another state entirely. So whether we have jurisdiction over that state, if it's really that state's fault, then we can't blame them.
Meaning they're not asking us to hold Tabetania liable because they're not part of this case. But they're saying exculpate us. So how do you address that?
Yes, Your Excellency. This agent respectfully submits that it was ultimately the act of Emperor Van Henezo of overriding the safety control mechanisms of the ANPP, which was the cause of the environmental damage to Rostavia, Your Excellencies. So going to breach of an international obligation.
No, sorry. Before you proceed, there were several factual circumstances that were brought out by second applicant earlier. I think including in the percentages in the water and the involvement of Tabetania. Can you address those? Because I think that's an interesting point to discuss.
Although this agent acknowledges that the ANPP explosions merely resulted in a 500 milligram increase, it was never conclusive that the 25,000 milligrams caused prior to the explosions of the ANPP was the cause of the damage faced by Rostavia. Ultimately, Rostavia suffered the hospitalizations, the biggest fish kill, and the damage to the Jessar River only after the ANPP exploded, Mr. President. Going back to my points, Your Excellencies, Abenubia in this case violated the principles of
So,
Secretary.
but there was also a report that the people going to the hospital, half of them or most of them were, mass hysteria.
Yes,
Experiencing hysteria. So maybe because they heard the news about the explosion, they thought that, oh my gosh, we're included in the victim pool. But they don't actually reside near the river, right?
Yes.
So how do you answer that?
Agent, sorry, that's one study. Another study, IATA, pointing to Tabetania, not applicant.
Yes, Your
Right.
Excellency. In paragraph 21 of the compromise, although 35,000 people were hospitalized and only more than half experienced mass hysteria, still 17,500 people still experience acute radiation poisoning and have experienced chronic
Well, these people, the 17,500, have been living near the river for years, and Capitania have been dumping toxic waste since 2017. Of course, they will get some sort of disease from that for living so close for so long.
Yes,
Right.
Which the second report, which I referenced earlier, saying IAEA is Capitania. No.
Your Excellency, although this agent recognizes that environmental damage is an erga omnes obligation, so it's an obligation that all states owe to each other, and that it is difficult to determine.
Agent, sorry, what's the relevance of that argument to the point being made? It's Capitania, not African.
Your Excellency, this agent respectfully submits that it is indeed difficult to determine who is primarily liable to the environmental damage. However, what this agent respectfully submits is that ultimately, Emperor Van Henes's act of overriding the safety control mechanisms still resulted in a 500 millirem increase in the Jessar River of average background radiation levels. And according to the gyro counters of Rustavia, the average background radiation levels in a river should only be 300 millirems. Therefore, this fact should not be ignored, and there is ultimately still environmental damage caused by the explosions of the ANPP. Proceeding with my next.
Again, what particular principle under international law did they violate again?
The two principles would be the principle of secotere and the principle of due diligence, Your Excellency.
Okay, due diligence. Is that means or conduct?
It's an obligation of conduct, not result, Your Excellency.
So we're not supposed to be talking about the damage.
Yes, Your Excellency, because in
What's
the
the source that it's an obligation of conduct?
this would be the pulp mills case, Your Excellency, and in the pulp mills case, a more recent case by the ICJ, it harmonized the due diligence obligation of states as well as the obligation not to cause transboundary harm. And in that case, it was held that when states fail to take all preventive measures to prevent transboundary harm, that is when they will be held liable. And in this case, it is apparent that Abenugit did not even conduct an environmental impact assessment. Their decision to hire Dr.
Where is that
Guillermo-
fact?
Yeah, where is that?
That they did not conduct an EAA?
It was not stated in the
So
contract.
should we interpret problems that way? If it's not stated, they never did it.
No, Your Excellency. However, even with the facts present in the
No,
law,
so what's your
Can
what's
you
your
pursue
position?
regularity?
that Abenugit violated its due diligence obligation.
No. Whether they conducted an EAA or not.
It cannot be concluded because the compromise does not explicitly
So it's
say.
inaccurate for you to say that they did
Yes,
not
Your
conduct
Excellency.
either. Okay.
However, Abenugit still failed in its due diligence obligations.
What's the
According-
presumption? Did they conduct an EAA or not?
The presumption is that they did because
So if they did conduct an EAA, how can you say there was no due diligence?
because one of the customary rules for an environmental impact assessment is that it must be a continuing obligation.
There is nothing in the compromise that says that they did not continue to conduct an EAA.
Yes, Your Excellency, this agent acknowledges that they may have indeed continued the
And the presumption is
EIA.
regularity, right? So we
Yes,
assume
Your
that they
Excellency.
continue to do so.
Yes, Your Excellency. However, they still failed in its due diligence obligation to inform the Decian states about the operation and Emperor Van Heneso's decision to override the safety control mechanism.
So there's a notification obligation.
Yes, Your Excellency.
Basic.
In the Corfu Channel case, Your Excellency, in that case, the ICJ held that Albania should have warned the approaching British warships about the mines in Albanian territory. Because Albania, precisely because the mines were in their territory, should have known of such risks. And in this case, Abenugit should have informed Rustavia about the risks of the ANP.
In the Corfu Channel case, we're talking about mines, right?
Yes,
So
Your
when a
Excellency.
ship passes by there, you're assured that that ship will be harmed by those mines,
Yes, Your
right?
Excellency.
If you take a look at this case, we're talking about a low risk as stated by Dr. Marielli, of the nuclear power plant in causing damage, right? So how can that case even apply to this case?
That case still applies to this case, Your Excellency, because the IAEA's best practices provides that the construction of a power plant should not be, for instance, as in this case, constructed 150 meters away from the Jessar River. And since the Jessar River is a river that runs across all the Dician states, it is presumed that Abenuvia had the due diligence obligation to inform at least the Dician states about its decision to override its safety control mechanisms.
Agent, are you familiar with the Lake Ladu arbitration?
No, Your Excellency.
Go ahead.
Going back to my point on due diligence, Your Excellency, Abenuvia should then have notified and consulted with Rustavia about the decision to override the safety mechanisms. And apart from this, Abenuvia already knew that there was an existence of 25,000 milligrams of radiation in the Jessar River. And due
Agent,
diligence,
what's the risk if the safety systems were overridden?
the risk in case the safety systems were overridden, according to the compromise, is that there would be a catastrophic failure, Your Excellency.
But did the studying the risk, say that it would expand in terms of effect to other states?
No, Your Excellency. However, it may be inferred that the explosion.
No, but if that's not the case, then what's the obligation? Where do we draw the obligation to notify, to consult, when there's no finding that any impact will go beyond your territory?
This would be under customary international law, Your Excellency. So, for instance, the Corfu Channel case, as mentioned.
What principle of the customary?
The due diligence obligation to notify and inform states about possible harmful activities.
Wait, so you're saying custom says that regardless of whether impact may go beyond our state, we have to notify and consult everyone?
Yes, Your Excellency.
Really?
No, Your Excellency. Rather, the states who may be possibly affected by such activity.
Yeah, but there's no finding that any impact, whether it's catastrophic or not, will expand in scope to other states. Why do you have to notify or consult them?
Precisely because the Abenuvia nuclear power plant was constructed just 150 meters away from the Jessar River, and that river runs across all the Dician states, including Rustavia and Tabetania. And according again to the IAEA, a power plant cannot be constructed very close to a river that, for instance, runs across states who may be affected by the construction of such.
Where does the IAEA say that?
The IAEA safety of nuclear power plants work, Your Excellency. However, this is not binding. The IAEA's work serves as an authoritative means to interpret the best practices in terms of due diligence, Your Excellency. With regard to my final point, Your Excellency.
Before that, Agent, can you give an example of a river that cuts across multiple states where instead of what happened in this case, the involved states decided to settle their disputes in an alternative manner?
In the pulp mills case, Your Excellency, the river that ran across, the river involved in the dispute was the River Uruguay. So this affected Argentina, Your Excellency, and Argentina was claiming responsibility from Uruguay for the construction of the pulp mills that would ultimately damage the river. So they were claiming that
But that reached the ICJ.
Yes,
I was talking about the situation where that potential conflict was resolved alternatively.
This agent cannot provide you with any.
The Harry Road River, you familiar with that?
No, Your Excellency, unfortunately. Seeing that I'm almost out of time, Your Excellency, may I proceed with my compensation arguments to conclude?
In 2 sentences.
Yes, Your Excellency. Considering that Abenuvia is internationally responsible for the environmental damage to Rustavia, then it can be made to pay compensation. Thank you, and may it please the court.
Counsel, just one
Oh,
question.
Go ahead from Judge Macaraeg.
How much?
In the Costa Rica versus Nicaragua case, the ICJ awarded Costa Rica for around $378,000 for the damage to the river as well as the restoration measures. And considering that this case also involves damage to the river, around that amount would be appropriate, Your Excellency. However, a separate proceeding
minutes.
Mr. President, Your Excellencies, again, good day. My name is Rafael Romulo, and I'm here to present my rebuttals. I have three for the members of the court. Firstly, the respondents erroneously confused jus ad bellum and jus in bellum. And secondly, the Italian manual interprets armed conflict, including cyber attack. It is the applicant's submission that the most highly qualified publicist includes progressive interpretation. If we do not accede to this, then cyber malware that
Agent, sorry, respondent did not comment on that submission. Why are you rebutting that?
it is for the clarification to the members of the court
Is that within the scope of an allowable rebuttal?
and to the argument of the respondent. And thirdly, the respondent has impliedly agreed that we have observed the due diligence required, as it stated that we conducted an environmental impact assessment, which is required in preventing transboundary environmental harm. And secondly, as if I may assist the members of the court to paragraph 22 of the compromise, it stated that chronic radiation syndrome requires years or months of exposure. Clearly, in paragraph 19, after the explosion, there was immediate chronic radiation syndrome to the Rustavian citizens. However, it is clear that this is to Tabetano. These are all my presentations. Thank you, and may it please the court.
Thank you, Ethan. Sir Rebut.
Agent, sorry, point of order. Are you addressing all points?
No, Your Excellency, just one. Mr. President, Your Excellency's good day. Applicant has 2 points for rebuttal. Respondent deems it necessary to address only 1 point. Applicant presented that respondent impliedly agreed that the due diligence obligations of Abeluvia were complied with because of the environmental impact assessment. However, due diligence looks at the circumstances of a case. And in this case, the existence of 25,000 millirems of radiation levels in the Jessar River, the fact that Dr. Marielli was a controversial nuclear engineer already, and that there was already the biggest fish kill along Rustavia's coast, shows that Abeluvia should have exercised a greater degree of diligence in constructing and operating the ANPP, Your Excellencies. If Your Excellencies are
No, we have a question. I want you to address the footnote 3 argument that was raised in the rebuttal. I think that's a good point. It says chronic radiation syndrome can only occur after months or years of chronic exposure to high amounts of radiation. Here, it happened shortly after. Then I guess it's not applicable.
Yes, Your Excellency. However, these are not conclusive to state that it was ultimately the act of Tabetania, which they are alleging is Tabetania's fault, that caused the environmental
Okay,
damage.
it might not be Tabitania's fault, but it's hard to say it's applicant's fault then. So how do you still pin the blame on them given the nature of chronic radiation syndrome?
Your Excellencies, because again, due diligence is an obligation of conduct. The fact that they did not exercise the degree of diligence required or expected of them means that they can be held responsible for the internationally wrongful acts and the environmental damage, Your Excellencies.
But you do agree with this footnote?
Yes, Your Excellency. Thank you, and may it please the court.
Thank you all.